in session. Calling case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, can you enter your appearances, please?
Chad Brunander, Ryan McBride, David Sturgeon of State, Mr. Jeff Gray, the County Attorney, and Chris Ballard are also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who's seated to my right.
Good morning. Mr. Robinson, good morning. For the record, the court also recognizes the presence of Ms. Erica Kirk. Ms. Kirk, good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at your tables have been turned off. Again, an attempt to try to minimize the possibility of any of the communications being captured. I ask that if you are speaking that you come to the lectern and that microphone will be live. And so that's the best way that we can hear you, and it is captured on the record. All right, second, the court will address the camera operator, and the court knows there is no still photographer for today's proceedings pursuant to the court's ruling from last week. To our camera operator, would you please approach the lectern? My microphone, there we go, now it's back on. Could you state your name for the record?
John Wilson, KSL News.
Mr. Wilson, what duties will you perform today?
Shooting the proceeding according to the decorum order.
All right, and have you had a chance to fully review the court's standing decorum order?
I have, sir.
All right. And you understand all the requirements set forth in that order as it applies to your activities today?
Yes, sir.
Do you require additional time to review the order or to adjust the equipment to ensure compliance?
No, sir.
Do you anticipate any difficulty complying with today's with the order or with any of the court's instructions?
No, sir.
All right. Well, thank you, Mr. Wilson. I appreciate you being here. Next, turning to the amended motion to allow the use of portable electronic devices filed by the news media and their counsel. The court appreciates the arguments presented in the motion and recognizes the importance of the press in the criminal justice system. Having considered the motions before the court, the request to permit representatives of the news media to use portable electronic devices during the preliminary hearing is respectfully denied. The request to permit counsel for the news media to use portable electronic devices during the preliminary hearing is granted. As officers of the court, counsel shall be held to the same standards applicable to the counsel for the parties and comply with the court's standing decorum order. I wish to turn to the matter before us today, the upcoming preliminary hearing, and the court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who are present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that the portable electronic devices will not be permitted in the courtroom or on the fourth floor. In addition, each person who is in attendance will be afforded the dignity and respect due to them, and pursuant to the standing decorum order, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. And the court recognizes that this hearing may invoke a motion from everyone, and the court understands the human nature of that, but also it's important that this courtroom is orderly. Spectators shall not wear or display any pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case, or the status of this case as a capital offense. Turning to counsel. Before we begin, I want to acknowledge that over these past 10 months, I've had a chance to observe each of you, and I find that you are all competent, prepared, and that you care deeply about this case. I ask you to continue to conduct yourselves in accordance with the rules governing professional conduct, civility, and ethics. I also ask that you remain mindful of the constitutional rights of all parties, and in every engagement that you treat each person you engage with the dignity and respect they are inherently due, as they are human beings. I want to turn also to objections, the format that I wish to follow if objections are made. When an objection is made, all parties shall pause so that the objection may be heard. Speaking objections are not permitted. If any party believes that an extended argument is necessary, particularly on sensitive matters, that party may request to approach the bench, and all parties will approach the bench. Both sides will be afforded an opportunity to be heard for or against the objection, after which I will issue a ruling either sustaining or overruling the objection. Once the ruling has been made, direct or cross-examination may resume. I anticipate that we will begin each morning at 9 a.m. with the exception of Wednesday, when we will begin at 1 p.m. We will take a 15-minute morning break and a 15-minute afternoon break. If there is a situation that necessitates a break, please approach the bench and we can address that. We will recess for lunch at noon for 1 hour each day, with the exception of Wednesday, and court will resume at 1 p.m. and continue until 5 p.m. each day. Does either party need the benefit of the record?
No, Your Honor.
Thank you, Ms. Nestor.
No, Judge, thank you.
Thank you, Mr. Grunander. Do either party wish to invoke the exclusionary rule?
Defense invokes, Your Honor.
All right. The defense has invoked the exclusionary rule. I ask that all witnesses, if present, be excused from the courtroom, and ask that each party monitor the courtroom to ensure your witnesses aren't present, as I'm not familiar with who they are. Of course, victim representative is excluded from that rule, as is the case manager pursuant to the rules. Okay, and I anticipate that from here on out that they're just going to come to the lectrum. So, okay, so just for the benefit of the record, to the questions, the yes or no questions. Well, the parties have entered their appearances, and they're all present, and neither party wanted the benefit of the record. Ms. Nestor invoked the exclusionary rule. And Mr. Grunander, if you'd like to approach the lectrum as the microphones at the tables are not activated.
Thank you, Judge. We anticipated that the defense would invoke the exclusionary rule. We consulted with defense for just a couple of minutes prior to the start of this hearing. We essentially have two case agents, Your Honor, David Hull and Brian Davis, both from the state of Utah. The defense has consented that both of them can be present. So one is seated at my table, the front table. This is Brian Davis, Agent Davis, and Agent Hull is seated on the bench just on the other side of the bar. He will be present for this hearing as well. Both of these agents will be testifying as part of the hearing.
Thank you. Ms. Nestor, your microphone's dead. If you want to come forward, and it sounds like you've stipulated, but just for the benefit of the record.
We have stipulated, Your Honor, for purposes of this hearing only.
Thank you. All right, so Agents Davis and Hull are permitted to remain in the courtroom during the duration of the preliminary hearing. Any other business that we need to address before we turn to the business of witnesses? Mr. Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson. Your Honor, the court had issued an order, maybe it was early last week, asking the parties to meet and confer about the question of whether exhibits will be published. And we did, and we can either deal with this as a general matter, or we can deal with it on an exhibit-by-exhibit basis. But I just wanted to make sure that we didn't lose track of that issue. The court had earlier entered an order granting in part the defense motion to exclude, I'm just going to say technology in the courtroom because it's a shorthand for video cameras and photography and microphones, because the parties had earlier stipulated that none of the exhibits would be available from the preliminary hearing, would be available for inspection or copying. I understand that publishing the exhibits in the courtroom may technically be different than that, but whenever the court is ready to deal with that issue, we just want to make sure that we do so
Thank you, Mr.
before
Novak.
it's too late.
That's always the right time to do it.
Okay, thank you.
Turning to the state in defense, do we anticipate this being a long argument, or is it something that we can handle? There are some stipulations that we can address right now, and then the remainder we can address on an exhibit-by-exhibit basis. Mr. Grunander.
Judge, I don't know that we have any stipulations, but with that said, it is correct, Mr. Novak's correct, we did meet and consult on this issue. I wanted to give the court just a brief roadmap, but part of that was exhibits 7, 8, and 9 that we propose introducing will be graphic in nature. And those were the exhibits I was referring to at the last hearing, where we would like to take a short break before they were published, if they are published, be by way of video and or audio. Judge, I don't see any TVs or monitors here in the courtroom today with respect to publishing something that would go beyond counsel table and Your Honor's bench. So I don't know how much this is of an issue this is going to be anyway, at least with respect to pictures or video.
Thank you. That's a great point. And the court's thought about this issue in regards to publication of exhibits. Obviously, the court will entertain all motions before any, but after considering it, here's the 2 points that I wish to address. In regards to the exhibits, there is benefit to publication of certain exhibits, but I also do not, and this is going to the camera operator, do not want them to be displayed on TV. I believe it is important that the parties know that the exhibits are being viewed by the judge in real time and in open court. However, what I will do is have the monitor placed against that wall to reduce the possibility of it being broadcast. And so on the exhibits that the court grants to be published in court, and not going to Mr. Novak's point, not to be given copies to, and the court is trying to be mindful that if it's shown on TV, that's essentially giving a copy to. And so the court is taking Mr. Novak's point in consideration. And so the anticipation is, and I know I'm catching staff a little bit off guard, is placing that television right behind Jeff, our bailiff, to minimize the accidental capture by the camera and allowing it to be displayed. I recognize that that is not the ideal spot for viewing, but I'm also trying to balance the rights and important considerations that defense has made. And again, this will be on an exhibit-by-exhibit basis on what is published or what is not. But for the exhibits that the court rules can be published in open court, that is going to be the location of the monitor And again, the court spent a bit of time weighing what should be done, where the monitor should be placed to accomplish the purposes of publication, at the same time protecting, especially as it may relate to sensitive material if the court deems that to be publishable in the courtroom. Any
Understood.
questions that I can address from either side, or clarification needed, or thoughts that you wish to share?
No, I think I understand completely.
All right.
Thank you.
All right. And Mr. Grunander, as it relates to that, are we anticipating the possibility of that coming up very soon in regards to publishing potentially exhibits?
Not real soon, but today certainly I would anticipate, Judge. For the course information, we anticipate presenting 4 witnesses. They're all law enforcement witnesses. Officer Chris Bagley, he's now with Spanish Fork Police Department. He was with Utah Valley University Police Department. He'll be the first witness. The second witness will be Agent David Hull, and those exhibits 7, 8, 9, we anticipate coming in through him. The third witness will be Agent Brian Davis, again with the state of Utah, a case agent who's here presently. And lastly, Sergeant Jennifer Faumoina, also of the Utah Department of Public Safety. And we do anticipate admitting between 40 and 50 exhibits.
Thank you. All right, Mr. Grunander, I apologize. You walked away before I got my question out. If we anticipate taking a break around 10:30, do you anticipate any potential exhibits for publication being requested prior to 10:30?
I do, Judge.
Okay.
I do. I think the first several exhibits should be published. So.
All right. Well, let's do this. I want our preliminary hearing to move smoothly and with the least amount of delays as possible. So let's take a brief break to allow the placement of that monitor, a brief test to make sure it's working, and then we can be seamless in moving forward.
One quick question, Judge, for counsel's benefit. Are the monitors at the tables going to be turned on?
The monitors are, and
Okay.
that's why I wanted to give that instruction early on for each party to monitor their monitor. Because if the camera is doing a wide sweep picture of the courtroom, I can't prevent the accidental capture. Obviously, the decorum order anticipates not focusing in to the point that is focused on your monitors. But I ask all the parties to be mindful, especially as it relates to the sensitive material that may be published or may not. But please just take a look at that and be mindful of that. But I will leave it to you. So I believe it's important that all parties see what is before the court. So if you have objections, it's right there. You can say, okay, I see what the court's saying. I have objection or not, or just to confer with your client. I just want to make sure that there is no misunderstanding of what's being presented, to allow all parties the benefit of the record, and it is clear what is being presented to the court for consideration as evidence. Thank you.
And we do have one exhibit that will be in physical form, and so we will be using the easel, I think, that's just
Okay.
over by the jury box.
All right. Thank you, Mr. Grunander. Before we break, I do wish to remind the parties that this is a preliminary hearing. It is a probable cause standard. And if you could keep that in mind as you're presenting your evidence, this is not intended to chill what you present, but keep in mind that the standard is probable cause, and that is what the court as a magistrate will be looking to. All right, with that, let's, how much time do we need for the placement of the monitor? All right, well, let's break for 6 minutes. Let's make it easy on ourselves. Let's just come back at 9:35, and we'll resume court at that time. Thank you.
All right.